G'day, Nina.
Hi, Andrew.
Here we are at Mount Buller.
I know.
Look at this, Mount Buller. Real.
Friday,
we've got paraphernalia.
briefing on the road.
Who would have thought we'd ever do it?
We're not going to make this a regular thing. Yeah. It is very hard to do it.
And by the way, we've been practicing while we're driving, so we're not as good as we usually are, but it's scenic.
But it's very scenic, and we have the most professional setup I've ever seen. So shout out to Toy.
Yeah, shout out to Toy. Well done. All right, well, look, let's start with the Australian cabling case, because I reckon it's a fascinating case. So this is a case where a contractor to a principal builder finished their job at the Tweed Hospital, and then said to their employee, no, we can move you down to Wakel, which is an hour and 10 minutes extra each way for the person. Driving.
But 2 hours by train.
And then when he said, well, I think that means I'm redundant, they said, well, we're not going to pay you. So they made application to waive the redundancy pay. Now,
to zero, not to reduce it, to completely make it zero.
So I want you to guess out there, did he get his redundancy pay? All of it, because it was clearly unreasonable.
Yeah, it's such a detriment.
Yeah, so look, interesting case, because it does highlight this idea that you must look at the individual circumstance and individual when you seek to redeploy to avoid the redundancy entitlements, but pretty funny case.
Yeah, and I think this case is important, especially for companies who are relocating, say, their offices, which is what we've seen before. Even in that case, same jobs, if you're moving your offices and it's going to be detrimental to people, so they have family and caring responsibilities, it could still be a redundancy.
And look, for major contractors who circulate between sites, exactly the same issue. Let's have a go at the IEU and preschool case, which is a supported bargaining case. You probably don't know while you're watching this, I just completely stuffed something up. But we're here. Okay. Now, look, this case is interesting because a supported bargaining application has been approved, which allows the IEU, which is the Independent Education Union, to actually seek to get an enterprise agreement that covers the field of all preschools.
Yeah.
Now, they don't have strong industrial rights. In other words, there's not a lot of enterprise agreements in the sector. The pay is very poor, huge levels of dissatisfaction. I think it's 37% of employees feel very dissatisfied by their working conditions.
Yeah, that's right.
So it wasn't a surprise that the application got up.
And it's supported by the employers, one of the big employers, I think.
Yeah, well, that's actually not surprising because what they're doing is crushing the smaller employers. It's a bit like the CFMEU and the big builders.
Oh, yeah.
Yeah, they agreed to the enterprise agreement, then nobody else can afford to exist. So and this is going to happen, and it's going to happen in private schools. It's coming to you shortly, private schools, because with the target of talent in private schools at the moment, the bigger schools will simply go, yeah, look, we can sort of go along with this.
Yeah, we can afford that.
We can afford that, but it will wipe out smaller private schools. And I think what larger private schools have got to understand is this is not a clever idea. And very soon, the large preschool provider is going to realise, hey, wait a second, everything we do has now been industrialised.
Yeah. All
of a sudden, we have delegate rights we weren't experiencing before.
You can't have any unique changes that are practical for your area because everyone else is the same.
Yeah. And the thing with these type of model, for want of a better expression, or template agreements is they cover the field. They're inclined to collect every single facet of it. So private schools are one of our major client groups. We've spoken to them about it, but can you please watch out? This is the warning bell that's coming. And there are other industries too, like aged care, where there should be genuine fear about what is going on. This change that occurred recently in the Fair Work Act is creating a level of risk and liability which goes back to the old, before the pre-modern awards, where we had respondency to awards. It's pretty spooky. Anyway, look, we're saying it because it's really interesting. It's out there. It's happening. And I didn't predict this. I didn't think the level...
No, it seemed like no one was using the provisions.
No, not at all. Anyway.
So let's talk about unlawful deductions because we see it all the time, right? And we all know there's really, really strict rules.
This isn't the one where they deducted $500 fines for...
Yeah, it was crazy.
So there's a $500 fine for them testing positive when they were in their residences for drugs or alcohol, not at work.
No, yeah, that's right. So this was an agricultural company and they made all these unlawful deductions. The first one was around drug and alcohol policy, which is if you had drugs or alcohol in the work provided accommodation, First would be $500 fine deducted from your wages, and then you would get fired. They also,
because obviously it does cost $500, doesn't
it's just
it?
crazy.
Yeah, it's that for the bottle of whiskey that the owners drank afterwards.
Yeah,
what is that
crazy.
about?
And then overcharged them for health insurance, also overpaid casuals, and then just deducted it without telling them.
So what happened?
So now they're being prosecuted by the Fair Work Ombudsman, and I think this is a warning shot because the total amount of deductions was quite minimal. It was $36,000, and they paid it all back.
Yep.
But the Fair Work Ombudsman said it doesn't matter. The fact that these are vulnerable employees, I think they're also under the PALM scheme.
Yep.
They said, nah, it's not good enough, and they're pursuing them for significant penalties now.
Okay, can we talk about rights of entry?
Yes, we can.
I tried to talk about this earlier, but I made a mistake. So this is CFMEU and JWL land, but mainly a person called Scott Henning.
Yes.
So this was a right of entry. CFMEU came in one day. There was problems with electrical boards. They didn't finish the inspection. It was a lawful entry, lawful inspection, high safety risk.
Yeah.
Came back the next day
with a different CFMEU
That's
organiser.
right. And then
they tried to be too smart by half.
Yeah, but it's using Dad's expression.
Yeah.
Too smart by half. Said, "Oh no, it's all done."
Yeah.
Oh.
Yeah.
And they were somewhere between 17 to 42 minutes.
Yeah,
I love
fluffing around trying to not let them enter. Yeah.
And I guess the court became concerned. The fine wasn't huge; it was $3,000 or something, but it was still significant. But what the court said is, look, this was a safety issue you were frustrating. Yeah. There was no proper. There's not even
no basis.
There's no proper basis for trying to do it. Anyway, can we talk about principal contractors?
Yes.
I've really not done this very well, but we're going to talk about principal contractors. Safe Work New South Wales, Menon, it's a case. Nina and I commonly explain to people that under safety law, as distinct from common law, the duty of care is one which is statutory, which means that a contractor is still liable for the risks that occur to workers of subcontractors. Okay?
That's right.
So in Menon's case, slightly more complex set of facts in that Menon employed a subcontractor to do some work. The subcontractor employed two subbies to do that work.
Two levels past,
Two levels of it. And what they were doing was they were putting some sealant in a roof, and Menon, the principal contractor, came along and said, okay, look, it's time for you to do that, but we're removing the scaffold. Which meant that these two individuals had to use an A-frame ladder, which was clearly improper, which meant they stood on the roof, and as a result of standing on the roof, one of them fell onto nearby residents. And what the court held, it was a quite significant fine, started I think about 225 or 220,000 and was reduced for an early plea of guilty, I think down to 180.
Yeah, that's right, 240 down to 180.
Yeah, is what they said is, look, you do something which creates an element of risk. You do no risk assessment when you do it. You provide no appropriate structures, safe infrastructures to do it. You're liable, even though they're not yours. And remember, in these things, the subcontractor who provided work for those two is probably separately prosecuted.
Yeah, would have had to do their own risk assessments.
But Menon was involved.
Yeah.
Right from the word go, it was the one who said, no, it's time to do it, principal contractor, to you, time to do it, at a time they knew it was not safe to do it in the manner it was going to be done.
Yeah,
End of story, really.
It's really interesting because I think most of the principal contracting cases we see is when they're liable because they see one of their subcontractors doing something unsafe and failed to stop it. But in this case, it just broadens that responsibility that if your own actions can make it safe, then obviously the obligation applies. So that would apply if you're just a normal
so please
employer.
don't get caught up in this stuff. Just remember, there is an existent obligation that sits on a principal contract to ensure the work undertaken beneath them is of a safe nature. Where there are specific skills and talents a person applies in relation to that specific talent, the principal contractor does not have a liability unless they observe something being done which is inherently dangerous. However, where it is a general knowledge of risk that it's vested in the principal contractor, they can't turn a blind eye. That's probably the simplest way of describing it.
Yep.
I want to talk about serious injuries.
Yeah.
Okay, I'm going to get this one right this time. So we've actually gone to the right case. I think all of us can be impressed with that.
Hailstone and Victoria.
Hailstone
Work Cover Authority.
So look, this is an interesting case and goes back probably 30 or 40 years to a long time ago, when the issue is when could you suffer psychological injury, and it was only when you suffered physical injury yourself. Now the law changed in the early 2000s so that you can suffer psychological injury and bring a common law claim through the workers' comp legislation and through parallel bits of legislation throughout Australia without suffering an injury. So that's step one. That can happen. The issue here is to bring a serious injury claim in somewhere like Victoria, and there are other jurisdictions that have thresholds that prevent you from bringing a claim. The issue is whether the nature of the injury that was caused psychological is permanent. And of course, nothing in life is permanent, particularly in psychological injuries.
Yeah.
But the evidence in this case was there was a man who observed another person get electrocuted when a crane hit an overhead wire. That person came, the employee came to assist with CPR. They themselves became electrocuted when they tried to start the car.
Yeah.
They continued to do CPR to keep the person alive until such time as the ambos arrived. He suffered PTSD.
Yeah, understandably. Horrible.
And what I want to say about this is, this was sort of grotesque in a way. It was such an odd thing to start challenging, where they said, no, it's not really permanent. It's not. This is the type of argument that really galvanises a judge into finding against you, because PTSD is not something that goes away.
No.
It may not be there all the time, but it is present, and it's triggered, and it creates risk.
And it's not always visible.
No, exactly. But there was no challenge to the evidence that he had PTSD.
Yeah.
And once you do that, you could see in the judicial commentary that it wasn't received well, was it?
Yeah, but the reasoning was so weird. Like, they said he can't be a long-term sufferer because he runs a business. He's in a long-term relationship. He plays football. So basically, the fact that he had a life meant he couldn't have conditions.
And this is when we speak to
sense.
employees and they say, look, we want to get this claim rejected because we saw this person who says they're depressed having a coffee. People continue to live their life.
And you should be glad that they are
That's
doing
right.
that.
Don't think that someone's doing something. We gave the case last week of the person who went overseas to Greece, I think it was, to be at his daughter's wedding. These things happen. I want to move on to the main topic now.
Yep.
Smart and BHP, great case to actually talk about investigations. I think you and I have been trying to say to people for a long time that the Fair Work Commission is taking an increasingly dim view of failures of good procedure.
Yeah, they're really focused on them.
Investigations. And I think this case is, to me, the epitome of where the Fair Work Commission is really getting its fingers in, because it was highly critical in investigation. What happened in this case is there was a technician who said some things which were clearly sexually harassing.
Yeah.
If you look on the scale of sexual harassment, where do they sit? At the sort of, if bad is 100, good is 0, it was sort of the 40%. They were rank awful things to have said. They weren't touching, they weren't the more...
No, just like more implications.
But they were clearly sexual misconduct in the sense that it was clearly sexual harassment.
And also like sex discrimination, like calling them useless and the B word and stuff like that. Yeah.
Now, what happened in the investigation was that a law firm had an embedded employee working for BHP who undertook the investigation. When they undertook the investigation, throughout the investigation, they continued to communicate with the leaders inside the business as what was happening. There was movement of drafts back and forth.
Yeah, gave them the draft report for them to amend.
And to amend. There were even broader concerns that the interviews were conducted on, virtually conducted on Zoom or whatever it was they were. Then when it came to actually telling the guy that he had to show cause, it was done over the telephone. He was given half an hour to speak to his union rep and came back and told he was terminated. He had no idea how serious what he had done. Yeah. The method of questioning was all through leading questions.
Yep.
There was an argument that it was an independent investigation, but the law firm who was actually defending the claim, it was their employee, it was embedded in the
So it was all connected, and there was just no procedural fairness, basically.
Yeah. The reason I'm going to say it is lots of people do this, okay? They were right, this was bad behaviour. But the wrongdoer was never really given a proper chance. The nature of evidence collection was so poor that it never allowed him to challenge it in an appropriate way or to give his own view of it. And he never understood at any stage the seriousness of what was occurring.
Plus, also, the valid reason wasn't enough for you. Like, there was no reason that you had to rush through the process in order, like,
They weren't standing him down. They weren't saying
it wasn't.
No one's safe because of it.
There wasn't like he wasn't causing harm to people in that time. So you could have followed due process and still got him out, and there would have been no risk.
And look, for me, I think one of the lessons that comes out of this is everyone's got used to using Zoom and Teams. Can you just not do it? When you want to interview someone, look them in the face. Body language, as the Commissioner said, is a critical thing. How people respond is part of the way you form a judgment on the truth or lack of truth of a person. Yeah. And look, the Commissioner didn't find that the technician was an honest person. So yeah, the Commissioner was not a friend of the technician at all. But what he said in the end was, this is just not good enough.
Yeah.
This process is so flawed. You can't be a proper thing to do. So look, when we're doing investigations, can we come back to what Nina and I repeatedly talk about? What do we talk about? Get a letter of allegations correctly drafted. Yeah. Meet the people. Take appropriate contemporaneous...
Do a proper show cause.
Yeah. Make sure the investigator is not engaging with the operational people who are involved. So if it's internally and it's HR, make sure they're not engaging internally with the operations person. And remember what we say, quarantine that person because that's going to be a decision maker. If it's somebody independent, make sure it is someone who's entirely independent who's doing it. And please, telephone calls to terminate. Are you kidding?
Yeah, no telephone calls, no text. And if it's serious misconduct, they should be suspended.
Yeah. Well, if there's a continuing risk, you'd want to suspend them, wouldn't you?
Yeah.
So look, there are comments. Why don't we go to the case study?
Big Vac was an international component manufacturing company for electrical engines. It had footprints in Melbourne, Brisbane, and throughout Asia and South Africa. The Melbourne factory was in Keysborough, and it had been there for 35 years. Jock was a machine operator. He had worked at the factory for 32 years. He was a rough and tough, gnarled old Australian man who had seen it all. Everyone knew what he was like. He was prone to calling a spade an effing shovel. It was tolerated by management.
I thought I'd get that in. I thought you might have done a Kim on that one.
He was part of the furniture. On a cold Wednesday morning in winter, he was entering the crib room, stamping his shoes to feel warm. He spoke to two young female employees. They later complained he made suggestive remarks and they felt offended. He was said to have made them in front of his supervisor, Joe Gordon, who said, "Cut it out, Jock, you know better." The two women were interviewed via Zoom by the in-house counsel, Tara White. She explained the investigation was under legal professional privilege. Tara had been instructed by the head of operations, Gavin Firth. He said to her, "This could be a nightmare. The factory is full of troglodytes."
Troglodytes?
What's that?
They're very old prehistoric creatures. Troglodytes.
Oh, okay. That's very random. There is so much risk and we are tendering to the Victorian government at the moment. This needs to be kept under wraps. After speaking to the women, she had a Zoom meeting with Jock. She didn't give Jock a letter, advised him she had to stand down and ask for his response to the allegations. He was a bit flustered but did his best. Her questions were very forthright. Did you... setting out the allegations. Jock was struggling with the technology and the idea that the women complained. He had said that stuff a million times before, but he denied he said what the women reported, but explained that everyone speaks like that. Why was he being blamed? He asked what stand down meant, and Tara said it meant you don't come to work, you will still be paid. Tara didn't speak with Joe Gordon about what he said, nor did she talked to him about the fact that Jock had said these types of things many times, as had others. Jock said he felt targeted and that the whole process was unfair. Tara did a draft report and sent it to Gavin. Gavin marked it up, taking out some things that implicated others. He added a comment in the email attaching the marked report. "I can't believe he's complaining about the process," he asked. Got to go. 2 days later, Jock was summoned to a meeting in person with Tara. She said she had found what he did was sexual harassment and he needed to say why she shouldn't terminate his employment. Jock was stunned. She told him to take a break for 10 minutes, then to come back and talk. When Jock came back, he said, "This is all bullshit. I've been set up." Tara informed him he was summarily terminated. So, did Jock have a good workers' comp claim around the investigation if he could prove psychological illness?
Well, the answer is absolutely yes.
Yeah.
But can I just go back? What happened in the Smout case was there is a rule of law that says if somebody gives evidence, and in Smout's case it was that he was a decent guy and he would never have meant it, or words to that effect, if it's not challenged, that evidence goes in. Okay, so that's what happened in the Smout case, and that was one of the reasons why the Commissioner said it's hard to understand the seriousness that is given the fact this evidence is unchallenged and I must accept it.
And so did they try to remove that from the report?
Well, no, they didn't. That's
just your
that's my part of it. So what we've got here is Tara's legal counsel doing in-house in-house investigation. I will come to the workers' comp part in a second. So Power Core says that when your role as a risk manager, not a lawyer doing legal work, that privilege doesn't apply. Quite clearly, part of what Tara was doing here was managing risk. Okay, so the report, everything in the report, and everything that happened comes into evidence. So I just thought we'd put that there because once you see that, you know the workers' comp claims are laid down in misere. What's our second question?
Does Jock have a good unfair dismissal and general protections claim?
What do you reckon? I reckon he's got a killer, hasn't he?
Yeah, there was no due process followed. I mean, we don't know exactly what the comments were in terms of a valid reason. But yeah, definitely no procedural fairness. And also...
For the general protection, he's raised the problem, this is unfair. And then the manager, Gavin, has written in, I can't believe he's doing this. He's got to go. It shows in the mind of the decision maker, a substantial part of the decision to terminate him was the allegation he made.
So that's interesting because I interpreted his comment as like, I can't believe he's complaining about the process at all. Yeah. And I thought he meant like he's got to go because the nature of what he did was so bad.
No, that's why I wrote it, because it could fall either way. But remember, when
it's reverse onus.
Yeah, when you see it's reverse onus and you see it in the document, he's got no way of walking away from that allegation against him. No way. He can say, oh no, that's not what I meant what Nina said. But the commissioner's going to look at him and say, it's not what the words say.
But also, that's clearly not the reason he's being terminated, because he's making a complaint about the process.
Well, no, I think Gavin's comment goes towards it. I think there's a risk. I think if the procedure was perfect, you'd bring a general protections claim.
Yeah.
Okay. A plaintiff lawyer would probably bring a general protections claim in any event because of the higher amount of involvement and the unlikely nature of him being reinstated given the conduct that he did. But the other issue here is clearly condonation, can I just say?
Oh, yeah. Yeah. Massively.
Yeah, so we'll talk about condonation in the end if I didn't make that a question because I've not read my questions yet.
I don't know. No, you didn't.
So, can we talk about condonation now? So one of the things is, as bad as what he has done is, if it is behaviour that he's done before, it's been accepted, or that others do the behaviour and it's known
and they get away with it.
And they get away with it. And remember, there is clear evidence here that he has raised it and that part has not been investigated.
Yeah.
I think they're in real trouble.
Yeah, because then it's definitely harsh.
Yeah, then it's definitely harsh. So he could easily be... Reinstatement's difficult because we don't know the seriousness of it.
And there's clearly a breakdown in the relationship. So
yeah, it's going to be hard. But interesting, isn't it?
So was the investigative process independent and fair? Well, no.
Yeah. So that comes back. So it's definitely not legal professional privilege. That's been wiped, okay?
Yeah.
So now you're looking just purely at the investigation.
Yeah, and I think the fact that you announced that the investigation's under legal professional privilege kind of waives it all. So
well, no, it doesn't really. You can say that. I can run an investigation and say, look, I've been engaged by lawyers to do an investigation. The investigation is privileged, but you will be given access to findings in relation to you. So that's the law. You can do it under privilege and say...
But then once they get it, they can give it to it. Then doesn't that waive privilege?
No. But what happens is it's Bowker's case that says at that stage you can't not give people findings. So in Bowker's case,
of course.
they just said, no, it's under privilege. You can't see them. No, you're in trouble. They just wrote a letter. And in what the commissioner said and then ultimately a judge said in Bowker's case is, no, it doesn't matter about privilege. You're not waiving privilege by providing findings in respect of them.
Oh, okay.
But you can't do an investigation in respect of a person and seek to hide the findings in respect of the individual.
Yeah, of course.
So very risky process, isn't it? So once you disclose privilege, you've actually made a rod for your own back.
Yeah, because it makes it seem suspicious. Like, why do you need to have it?
And that's why the two-step privilege process, where they're engaged independently by the client
and then
hired by you through privilege works. But it's a terrible investigative process. We haven't put all the problems of SMOUT in there, but you can see different problems arising here.
Yeah, and I guess changing and removing evidence.
And all I'm saying, Nina, is I just want to raise these because I think maybe once a month we get one of these really compromised ones, and there's only so much that we can do to cosmetically clean it for the purpose of litigation, because once it's done, it's done.
Yeah, and the fact that they didn't even check with other witnesses, like they really cherry-picked the evidence.
Yeah, I know.
That's not great.
Well, look, any other questions?
Yeah, so was Jock's psychological safety protected?
No, it wasn't. So if we look at psychological hazards, I threw that in because it's right in the middle of this, you've got clear breaches of psychological hazards.
No.
I don't think anyone would be prosecuted, but, but once again, you've got a psychological breach which gives a general protections claim.
Yes.
So you're off and running with it.
Yep. So they're screwed.
They're screwed.
Yeah.
Well, thank you very much for coming up to Mount Buller with me.
No.
You're in a dorm. I'm in a house. How lucky you.
It feels very different, but it's big. Tom and I have to. It's like a 10-person dorm or something. It's huge, but it's nice. So we're very looking forward to it. But tune in next week where we're back in Andrew's office.
There we are. Okay, thumbs up.
Thank you. Give us a thumbs up.
Thank you very much.
Okay, bye.
See you later. Bye bye.